if for a minute it were to be accepted that people who are pursuing a political cause within the meaning of Article 38 of the Constitution will be tried in Kahawa, we shall not only make a mockery of our national security, we shall also end up weaponizing the law made for terrorists to deploy it against those that we think we disagree with politically. And that is where the issue of political persecution comes in. And Your Honor, we urge the court not to go back that road of weaponization of the judiciary against sections of the Kenyan citizens with opinions that inconveniences the government of the day. The government of the day. We've been there before. It was a catastrophic time, and the reason why the 2010 Constitution exists. Your Honor, that point I make it with regard to two last issues that I'm about to make. Sections 42A of the CPC, Sections 42A of the Criminal Procedure Code, these sections, Your Honor, says it talks about the disclosure by the prosecution. 42A1 says, pursuant to Article 52J of the Constitution, the prosecution shall inform the accused person in advance of the evidence that the prosecution intends to rely on and ensure that the accused person has reasonable access to that evidence. 2 is the one that is most important. In the proceedings under the Prevention of Terrorism Act, the Narcotic Drugs and Psychotropic Substances Act, the Prevention of Organized Crimes Act, the Proceeds of Crime and Anti-Money Laundering, and Counter-Trafficking in Persons Act, the prosecution may, with leave of the court, not disclose certain evidence on which it intends to rely until immediately before the hearing. Then the other provision sets out. You know, why is this section important? This section is important for the simple reason that because terrorists are such dangerous people, that we've read, it's a CPC, sections 36A. CPC, section 36A. Just sorry, 42A, sorry. We were dealing with 36A, the other side. 42A. Yona, what is it about this section? Yona, what these sections is based on is because those specified offenses are deemed to be of such a severity and so harmful to the public and to national security that despite Article 50 of the Constitution, the state is allowed to prosecute the case without availing all the evidence at the commencement of the trial. That is an absolutely important issue because one of the most important safeguards, you get the materials for your trial. So when you try a terrorist, you use a lower threshold. You can keep some of the evidence, you can suppress, which is not possible with the crimes that they were initially charged with. They were initially charged with. So that, Your Honor, the point that we are therefore making with regard to sections 42A is that if you agree that people pursuing a political cause will be charged under provisions of the law and before a court under which they will enjoy less protection, it would be a very, very dangerous thing to be done. The final point, Your Honor, is on the famous Githunguri versus Republic case. I believe this is a case, 1986, we all know it. I am a fan of listening to interviews by JSC when people are being invited to be for higher offices. Majority of judges cite this case as one of their favorite decisions. And I believe it is for a good reason. And what's the main point of Githunguri that I want to urge today? It was about abuse of power, abuse of court process. But more importantly, there is an important phrase that was made in the language of the famous Justice C.B. Madani, to the effect, Your Honor, that a good prosecution or a lawful prosecution is determined at the commencement on how it starts, not how it ends. We have submitted. This has started as terribly, as unlawfully as it is possible. I have heard from the prosecution when it was responding later on that, oh, we shall sanitize this. We shall give evidence. Everybody will be satisfied. Let them wait. Your Honor, in the case of Githunguri, the point was, what is unconstitutional in a demonstrable manner cannot be sanitized, cannot be constitutionalized. I urge the court, and I thank it for giving us time to ventilate that issue, to dismiss this, and to discharge specifically the accused person until they are lawfully presented before this court. Your Honor, we are most obliged. Thank you.
I wish to add 2 points to what Mariam said. Constitutional question. Excuse me. Yeah? Your Honor, I wanted to address these issues together with what my language is raised. The doctrinal application. It is implied in Article 160 clause 1, where this court is presumed to be independent and impartial. And Your Lordship, you derive your powers from the people of Kenya under Article 159.1 of the Constitution. So I want you to read Article 159.2e. It obligates you to apply for any demonstrator, then you can now assign that indicated, Your Honor. And that's why they are all bound by Article 1 and Clause 2. The Constitution Now, if they, in the charge sheet, they are saying that a court of law was either destroyed by Article 160 Clause 1, judicial were submitting that in view of the context of these charges, when you look at Article 2 Clause 4 of the Constitution, it is violated. And to the extent that they violate Article 2.4 and the other if a prosecutor is signing a charge sheet, the condition is name and the rank of the prosecutor. On that ground alone, we don't need to be academic. This is not rocket science. On that ground alone of that charge sheet, the face of it, AA and PP, we don't know who AA is. So he cannot be held into account. So that if there is a problem, we can pursue him in civil proceedings to get to recover damages. So we don't know who AA is, and I know I have tremendous respect for the DPP because my wife has worked as a DPP back at retire. So I have tremendous respect. So I am saying this from the bottom of my heart that they need to be accountable, and that's what we are demanding. Yes, yes. Your Honor, for that, I think I've added some value to this process.
Absolutely. Absolutely.
Your Honor, from the law side of Kenya, allow me to start by saying that we wish to adopt our submissions, especially in the points of law in regards to the propriety of the charges facing the two subjects for the court in totality, so that we save them time. In fact, for the record, the submissions are in reference to E68 of 2025. Your Honor, the past, our submission is in reference to the time that we just brought before. I'm adopting it, yes. Your Honor, the persons before you are currently enjoying orders of this court in reference to their liberty. This is pursuant to miscellaneous criminal application E290 of 2025 in the Chief Magistrate Court at Kiambu. For purposes of record, allow me to just reiterate the offenses that were alleged to have been committed by two. One is arson, contrary to section 332 of the Penal Code. The second one is malicious damage to property, contrary to section 339 of the Penal Code. The third one is robbery with violence. Nonetheless, Your Honor, this is a court file. I am very sure that the court has judicial notice, so it's a public document. All I am trying to say, in the interest of time, is that the offenses that the past before you had allegedly been brought before the Kiambu court on a miscellaneous to have custody of them were serious offenses than the offenses that they have allegedly been brought before you for plea taking today. And I am not in any way saying that offenses related to Porter are not serious. But the ones I have cited carry mandatory sentences that are extremely punitive. Your colleagues in Kiambu agree in those offenses with the respondents and afforded them bail terms. I am reading the National Police Service standing orders at chapter 15. This is at section 2 on detention of arrested persons. Section 2(2)(d). The import of this section, Your Honor, is to guarantee the enjoyment of the fundamental right to bail and bond of a person by a police officer at what the masked and hooded men and women wearing the Kenyan National Police Service insignia who whisked away the two failed to appreciate on that day is that the law was not on their side. Before arresting such a person, they ought to have made an apprehension report under section 37 of the CPC to yourself or any other magistrate within the definition of the Chief Magistrates Act. To have the person remanded. That was not done. Your Honor, in Law Society of Kenya and 5 others, I am buttressing what Mr. Kibe Mungai was saying. In Law Society of Kenya and 5 others versus Mukunji and 5 others. This is a constitutional petition E373 of 2024. Your elder brother, Justice Momuye, elder brother, 373 of 2024. In order number 1, your elder brother, Justice Momuye, rightfully directed that no member of the National Police Service would use any masked form of identification on their person and or on any instrument
or vehicle that they use while conducting lawful arrests. What I am saying in summing up is that the subsequent alleged arrest of the two persons before you are in themselves in contravention of the law. Contempt is a jurisdictional action. It challenges the authority of a court, and the court has to down all its tools to address that issue first, although that's not what we are saying right now. That subsequent rearrest was not an arrest. In all definitions, it was an abduction. And since there cannot arise a legality from an illegality, I know my brother, Mr. Ndegwanjiru, has a Latin maxim for this, although you won't allow him to say it, is that no lawfulness can come out of this process. As I wind up so that I can allow my colleague, Mr. Guringa, to sum up, is that the courts of law must continue to function objectively to safeguard the historical development not only of public institutions but of the public trust. If our lawmakers, and I thank Senior Counsel Dr. Stephen Kalonzo Musyoka for giving us a historical context into this, had not included the proviso, then Article 37 would be at liberty, would be at a peril. As I wind up, because I also don't want my colleague, Mr. Ndegwanjiru, to say anything probably to upset our scales, is that if a police officer shoots a member of public in glaring daylight and on the anchor of a video camera, doesn't it amount to intimidating or causing fear amongst members of the public or a section of the public? Again, from the Law Society, we advise the Office of the Director of Public Prosecution to reconsider that decision, because the decision to charge policy also allows them to reconsider a plea before it is taken and use their resources for causes that will instill public trust in their function. Your Honor, from the Law Society, we are extremely grateful for your candor. I know you've been seated there for a long time. Some of us have walked out and have walked in. As a final submission, as you conclude to determine this matter, we thank you and we wish for your courage. I allow my colleague, Mr. Nguringa, to sum up in 1 minute.
Your Honor, I wish to briefly submit in the strict sense, and I wish to draw the court's attention to Section 71 of the Criminal Procedure Code. And this is a section which seeks to tether the trial of offenses where they have happened locally to be charged there. And Your Honor, as you retire, I want you to appreciate that we interpret our laws in view of the obtaining circumstances. And the obtaining circumstance here is that the accused persons are officials of a national political party. They being officials of a national political party, and courtesy of the submissions by the counsels for the defense, led by Senior Counsel Dr. Kalonzo, is that this trial bears the hallmarks of a political persecution. So, what I try to tell you, Your Honor, is that the public is following, besides us, the legal experts. And there is always an assumption and a conclusion from the public of every ongoing trial. And the word that may pop out is, could this be forum shopping? Your Honor, there is need for this court to address that point, whether this was forum shopping. And as a wind up, I believe it was not the intention of the legislature when it was making these laws to create what I can call legal mats. Your Honor, the accused persons have been charged in Kiambu. They have been charged in Luiru. Is that the case? And now they are here. We don't know whether from here they will be charged in Garissa or Mombasa. So that kind of nomadism need to be discouraged. And how do we discourage it? By breathing life to Section 71 on the ordinary place of trial. An argument may arise that yes, we don't have a court in Kikuyu. Fine. But there's one in Dagoretti, very near. There's another one in Limuru, very near. And my appreciation of a court is not the courtroom. I was practicing when Gatondo Locos was banned down, and another room was arranged for that. So, Your Honor, I leave it at that.
Your Honor, before counsel, maybe you should clarify the case numbers for which the accused person were charged in the Kiambu and
Your Honor, this is something in the record. This is something in the record, and we can use a better word, presented. But while I'm still on my feet, I have one. It's a miscellaneous criminal application. Almost surprised. You know, whenever the DPP stands on their feet, our adrenaline lashes. Yes. So I was at the tail end, and so Your Honor, you need to breathe with that second, in view of the ongoing realities and the need for the court to appear as a neutral arbiter. So I thank you for this.
Your Honor, I invite this court, Njeri Minor, to take judicial notice that the first accused person, Peter Kenyanjui Kawanjiro, intimated this morning to counsels that while in custody yesterday, a tear gas canister was thrown in the cell where he was held in by an officer, Your Honor, by the name Chef Koech, which is subject to confirmation, and accompanied it with the words Kufeni Wote. It is therefore imperative for this court to take judicial notice of that as you rest to make your ruling.
Your Honor, Only 1 minute, Your Honor. Just to add on what my learned friend has indicated, she has exempted one part of the statement, and our client is here. Kufeni nini nyote munasumbua serikali. Permit me to take you to the 30th of June, 2025. Where a police officer shot in broad daylight during protest a man named Boniface Kariuki. The circumstances of that shooting and killing were as they were on the 25th of June. That was 30th of May, sorry. But that's during the demonstration for Albert Bajwa. But that officer was not brought before any anti-terrorism court. Yet the circumstances fits and suits the definitions under Section 2 of the Terrorism Act. It tells you there is a double standard in the manner in which the DPP is executing its functions. Finally, in summary, the doctrine of exemption created by Section 2, which our land senior counsel, His Excellency Dr. Kalonzo, referred to, exempting protests from acts of terrorism, underscores the necessity of distinguishing between peaceful political expressions and violent acts, thereby upholding democratic principles and protecting individual rights. If that then would be the test, and if the court would be inclined to applying that as a test, it therefore would mean that the charge is stinking to the high heavens, and that this court, to the extent of the potters, lacks jurisdiction. Amos.
Our quorum from the Law Society has increased. We have Mr. Brian Machine.
Yes, Your Honor. I'm present.
He was in Milima.
Thank you, Your Honor. I've been listening to submissions by the defense. And before proceeding to make my submissions, I'd like to highlight, I think, one issue that has become a contest in these matters. Peter Kinyanjui and Sarah Wanjiko, before this court, are facing the charges of commission of a terrorist act. You know, that offense is in our law, and particulars are given. We have the statement of the offense and the penal provision of the said section. And the matters as to the proof whether they are guilty of the offense alleged is a trial process. A misunderstanding, Your Honor, and misreading of the law has been applied by the defense, especially in respect to the exemption under Section 2, where the law provides an exception under Article 37 of the Constitution. You know, verbatim, after listing the terrorist acts and the aims, which you have all agreed, Your Honor, they argue that all the destruction happened during a protest. And we agree. There was a legal protest, Your Honor, that was ongoing. What we do not agree with them is the actions that ensued during the legal protest. And that is why the law says, provided that the act which disrupts any services and is committed in pursuance of a protest, demonstration, or speech of work shall be deemed not to be a terrorist act. That is the law. If the disruption, there was no government offices, was not being used, Your Honor, the public transport system, in pursuance of protest, Your Honor, and notices had been issued. Up to that point, there was a legal protection. And is within the meaning of this, there was a legal protection. And is within the meaning of this definition. Is not intended to result in any harm. In our charge sheet, is not intended to resort to any harms referred as to paragraph A1 and 4. 1 to 4. So when you go back now to say A, 1 to 4, you will see that any act that happens under the said provisos is exempted from a peaceful, protected. You know, and now the act of terrorism, in a very plain understanding, or breaking it down to everyone to understand, it only transits to a terrorist act once you cross the line under Article 37. The Article 37 is protected, and you are acting, and the demonstration started under Article 37. But once they crossed that line, and their action resorted to paragraph A, 1 to 4, then terrorism charges began. Terrorism acts began. Belabor at that point. Your Honor, there were issues that were brought to fore about abductions. And from the word for the defense was submitting from the bar, you've been given nothing. Nothing to show that indeed there were abductions.
Your Honor, politely, I think this is something the public domain, the judiciary itself appreciated the same. So you cannot be from the bar.
And again, I will just again to guide. Yes, you have an opportunity.
Yes.
Yeah. Yes.
Thank you, Your Honor, for your protection. Your Honor, what I was saying before I was disrupted by counsel. An abduction is a legal term. You cannot just throw it left, right, and center. And whether that was an abduction or not is subject to a trial. Requires evidence. And what I'm saying is that there was no evidence that was tendered by the defense in support of an allegation that there was an abduction that transpired when the two accused persons were being arrested. They've equally submitted, Your Honor, on section 37 of the CPC, but allow me to take you back to section 21 so that we can move from down up. Your Honor, section 21 gives the police the power to arrest, and the arrest begins at touching. Once you are touched, and then it goes up to confinement. From confinement, it gets to all means necessary, And from all means necessary, and this depends with the reaction of the person being arrested, the law says that no greater force than necessary may be exercised. So there was an escalation from touch, but there was no all excess force that was used than was necessary, and that is our submission. And if indeed there was, now that becomes subject to trial. The defense, or people alleging that more force than necessary were used, then the burden shifts to them to prove that indeed there was more force used than was necessary. So abduction, we submit, is a legal term that has legal interpretation, and what transpired is not an abduction, but an arrest. They've equally, submitted that there were other charges that were facing the two accused persons before this court. With all due respect to counsel, there were no charges that were before any other court in the Republic of Kenya. What they are quoting to you are miscellaneous applications for custodial orders pending charging before any court of law. And that is why they've not presented any charge sheets before this court, because indeed there was none. If they are candid enough, they would admit that what was there was a miscellaneous application. And after a decision was made, from the circumstances and the evidence that had been gathered as at that time, with terrorism, and they were therefore now transferred from the initial trial, the initial court, to the current court for terrorism charges. Kahawa Law Courts has jurisdiction to try terrorism from any part of this country. And the charges before you, whether they are of more serious nature or less serious nature, they are terrorism, and therefore brings the accused person at the scope of this court. Let me go to Section 36, of the same CPC. It provides for detention of persons arrested without warrant. Gives the police power to detain people arrested without warrants. Section 36 provides for detention of persons arrested without warrants. And immediately after Section 36, you've been told about Section 37, that they are supposed to report the apprehension to a magistrate. You see the selective reading of the law. Get that Section 37 talks and alludes to Section 36, that after detention by a police officer, then the office of the OCS of the police station have, the responsibility to report that apprehension to the nearest court, And on 4th of July, 2025, that was the date of the arrest, which was on Friday, past working hours. The Constitution says that this apprehension, they must be taken to the magistrate within a reasonable time, 24 hours. And if the 24 hours falls outside the working before the court at the end, before the end of the next court sitting day. 4th of July, 2025, they were arrested after court hours. On Monday, the 7th of July, they were arraigned before this court, and the court was informed of the arrest, and the matter was then deferred to today for plea taking after arraignment, Your Honor. There is no impropriety, illegality, or abduction. Consequently, from the arguments of Section 36, 37, and the Constitution under Article 49F, 1 and 2. That having been said, Your Honor, the two individuals before this court, you are told that they are party leaders, and that is their right. We are not here because they are party leaders, Your Honor. We are here because a charge has been approved, and the jurisdiction of terrorism charges are before this court, Your Honor. Most of the arguments being proffered here, I can say that they are being proffered before a court that is not sufficiently equipped to give that decision, since the decision seems to be challenging the ODPP decision to charge Ada Porter. Your Honor, in legal terms, what they are telling you is, can this decision be reviewed judicially? And if that is so, if that is what they are asking, Your Honor, the court that is to deal with the processes and to check any excesses in terms of whether the decision was appropriate or not is the High Court on judicial review. Therefore, any argument as to whether plea will be taken or not, Your Honor, whether the charges are appropriate or not, cannot be legally and sufficiently heard before this court. And without a court order staying this court for plea taking, and a decision to charge having been made, then the plea, the most appropriate lesson or course of action to take is to allow, Your Honor, the plea to be taken. The remedy under judicial review does not expire upon plea taking. It subsists the plea taking until the trial is completed. Your Honor, there are some few issues that have been raised about tear gas, and kufeni nyote nyinyi nyote, you know, such sentiments, Your Honor. And unfortunately, these are sentiments by two counsel for the defense. We do not know whether they intend to swear any affidavit to that effect, since information from the bar cannot form any, you know, legal force of law unless it's submission. That information has to be communicated in a format known as an affidavit, and not through hearsay from the two defense counsel, but by the person who was addressed. And I'm very force of law unless it's submission. That information has to be communicated in a format known as an affidavit, and not through hearsay from the two defense counsel, but by the person who was addressed. And counsel can submit as such. If indeed there was a police officer who did that, that is an illegality that we cannot even entertain. Let them follow the right channels so that we politics from law and law from politics. Finally, as I sit down, legally, Your Honor, there is presented by the defense, whether constitutionally or through submission, that has raised reasonable grounds, Your Honor, to stop plea taking today. The issue as to whether these are the appropriate charges or other appropriate charges should be preferred, Your Honor, is not an issue that can bar plea taking. And we wish the court to find that the charges are before this court. These people have been registered appropriately within 24 hours, and plea may be taken, Your Honor. If I have two colleagues, Your Honor, they may address the court.
Your Honor, just to buttress the point of my senior colleague, and I will submit on the issues and the application that is being made by my senior counsel, Mr. Kibe. On the issues, the arrested persons were infringed when they were being arrested. Your Honor, these issues are 49 of the Constitution. And so, counsel should be telling you that his clients were denied counsel, or they were not brought before this court within the 24 hours rule as stipulated by the Constitution, or they were denied counsel, or other issues that are outlined in Article 49 of the Constitution.